Congratulations! You made it! You found the first video of the 13 Secrets of the Rich or Informed. The topic of this video is basic living trusts. First off, remember, living trusts are not just for the rich. It is for the informed as well. What I just said is the key to your decisioning in this matter. I'll say it again, living trusts are not just for the rich. It is for the informed as well. To remember this point, just remember the title of my cheat sheet, The 13 Secrets of the Rich or Informed. I named it that, back in 1990 to date, to remind us all of that truth. I'm Richard Rydstrom, a California lawyer with over 33 years experience. I'm rated 10 out of 10, superb. Sit back and relax, let me try to fashion a clear, confident path to step 1 of family and wealth protection. Notice what I said. I said a clear, confident path to family and wealth protection. That's family as well as wealth protections. This is protection from the court system, protection for the family and powers over the person, as well as powers over your wealth. The living trust is step 1 to that goal, whether or not you're rich. In this video, I will share the basics, and the key points you should know when considering a revocable living trust. Remember, I have actually drafted and used, and I usually see, the living trust as the quarterback for life decisions and contingencies, even for basic or very complex estates. The picture of the trust is an actual living trust package drafted by me. I took this picture with my phone. It's real. I did this so you would see the actual end product of a common living trust. It's the what, and what you need in a common estate plan. I'm not going to give you legal definitions like the many lawyer videos out there. But I do have to say, that you, and or your spouse, or domestic partner, would be the makers, or trustors, of the trust. The makers transfer certain and select assets into the name of the trust, and the trustee manages the trust and its property according to your written instructions. The trust and its related documents enunciate your instructions and intent as to you and your family members, and your assets, during your lifetime, during incapacity, and in the event of death. One other key goal or benefit of the living trust is the avoidance of court probate. Usually if you have a will or no living trust, your family members will have to go to court probate. That means you have lost your privacy over your family and asset matters. Also, in a nutshell, going to court is expensive. Going to court for probate is expensive and usually riddled with great delays, costs and fees. So, it's true, the avoidance of court probate benefit of the living trust should be a primary goal. Also, the living trust package integrates your instructions and wishes as to end-of-life decisions. It also defines your intentions as to your children. These are key and important matters that most clients desire to predefine and keep private, to the extent possible. At this point, please allow me to add some technical legal information and point out a few more goals. In October 2022, the lifetime estate and gift tax exemption was slated to go up to $12.92 million in 2023, up from $12.06 million in 2022. That means rich people can transfer more to their heirs during life and at death. So generally speaking, taxes are not a big issue for couples with much less than $25.84 million. The annual gift tax exclusion went up from $16,000 in 2022 to $17,000 in gifts per year in 2023. It was common to structure the living trust in 3 sections to maximize tax exemptions. For example, the A trust, the B trust and the C or QTIP trust. Upon the death of the first spouse, the surviving spouse would remain with the revocable A trust, and the deceased spouse's property would allocate to the irrevocable B trust to the extent of the bypass trust exemption amounts, and any excess would be allocated to the C or QTIP trust. In addition to tax motives or efficiencies, these trusts could also define certain control in the B or C trusts. So why do I still say you may need a living trust package? Because it's not only about taxes. The answer is because it protects the rich or the informed. Primarily they use it to avoid court probate. Also, the informed use the living trust package as its quarterback to direct the contingencies over the person and estate for themselves, their family, business, retirement, and children, during life, incapacity and at death. Specifically, they use it to define who and when their property is used for others or transferred to others. But let's talk about our children. Yes, the informed use it to predefine the decisions for their children during their life, at incapacity and at death. Let me quickly give you a short list of appropriate documents contained in my California Living Trust Package. Normally, the makers of the trust define these decisions in their living trust itself, and the pour-over will, which is a catch-all that includes property left out of the trust for any reason, if not otherwise designated, like with a pension, life insurance or retirement pod, or other trust like a life insurance or children's trust. They also define their healthcare, incapacity, end of life, relief from pain and agent decisions and designations in their advanced directives. They also name their conservator over their person and estate, usually their spouse. Additionally, they define their attorney-in-fact agent for asset management decisions. Let me also dispel the use of inexpensive online state will forms. Making no will or living trust will trigger court probate at death. The use of a will alone also causes court probate, its delays and expenses, including will contests or lawsuits. So those choices are not usually desired for the reasons stated. Now let's talk about children again. Notably, they also name the guardians over their children to make all decisions relating to health, education, maintenance, support, and welfare, to the extent of undefined discretion, and the scope of law. It is important and key here to note that the law generally has power over minors. California Probate Code Section 2590(b) states, "The guardian or conservator does not have a power specified in Section 2591 without authorization by a court under this article or other express provisions of this code." So, the court remains with the power in its discretion to grant the guardian or conservator any power specified in 2591. That's Section 2590A. Generally, the court looks for a showing of necessity, explanation, and intent to grant or uphold a power over your children, as necessary, appropriate and/or useful. Therefore, the living trust package and a special nomination of guardians of the person or estate of minor children should also include a special expression of nominations, wishes, intent, priority, necessity, and prescription, for concerns over our minor children's health, welfare, medical, housing, schooling, incapacity, and final wishes, with consent of Sections 1500, 1501 and 1502, et al., to the extent allowed by law. So, a primary goal for most makers of a living trust is to avoid court probate, contests, and lawsuits, including guardianships, or conservatorships. Finally, with that said, you have the power to change your instructions, or revoke your revocable living trust. Doesn't that itself make the decision to go with a living trust safer? I think so. Therefore, the living trust is needed by many Californians, whether or not you are wealthy. In closing, and for those who need a bit more legal talk, let's say it this way. 1. The revocable living trust. The public knows this device as a living trust. The living trust is most often used to avoid probate, its costs and delays. In tax circles it is called the IRC Section 671 Trust or Disregarded Tax Entity Trust, similar to the Tax Regulation 301.7701 pass-through concept. It is generally a tax-neutral device. However, you may use this trust to invoke maximum estate tax exclusions for the spouses or domestic partners, and to add no contest clause to protect against some third-party challenges, but because it's revocable, the living trust is not an asset protection device, until the death of the first spouse and the creation or funding of that trust is irrevocable. With proper business and estate protection planning, the living trust is commonly used to hold, select, property and all of your personal property interests. No, not everyone should have a living trust, and sometimes we intentionally cause a limited probate for reasons including to get shorter statute of limitations to limit lawsuits or attacks. 2. Most persons commonly use the living trust in business and estate protection planning as a central planning device or quarterback. It is part of most business and estate protection plans, as it can avoid probate and act as the directing authority for all or most of your property disposition plans, including certain investments. Although certain investment accounts are considered POD, accounts that avoid probate, or payable on demand, you should coordinate PODs consistently with your estate, business, and retirement plans, which includes your living trust. For some estates, this device alone is not sufficient as a business, estate and asset protection planning solution. To have maximum effectiveness, it should be used with one or more of the other devices or techniques mentioned herein below. 3. In larger estates, it is often advisable to put certain assets in various other devices, e.g., LLCs, children's trusts, life insurance trusts, C or S corporations, private retirement trusts, IDITs, pensions, etc., for asset and risk protections, as well as for tax reduction reasons. Interests assigned into certain other devices may be assigned to the living trust. Contrary to myth, generally it is not intended as an asset protection safeguard, at least during life, while it is revocable. Assets held in your living trust are not protected from the reach of creditors. California Probate Code, Sections 18,200, 15,304, 15,304b. However, you can achieve some measure of property characterization protection, as separate or community property transmutation agreements, etc., if the husband and wife maintain separate living trusts with property agreements. Well, I think we did it. Congratulations for watching this entire Living Trusts basic video as part of our 13 Secrets of the Rich or Informed series. My position is you should retain an attorney and fully explore your options and means to obtain your goals. There is no one-size-fits-all in the law, you are all unique. If you have a small business, watch video 2 of this series. If you have a large estate or lawsuit or retirement funds to protect, be sure to watch my Advanced Trust video 3 of this series. Thanks again. Rich Rydstrom, California Attorney. Call 877-WIN4U. Wealth.Attorney, Legal Notice. IRS Circular 230 Disclosure Notice. To ensure compliance with IRS requirements, we inform you that any U.S. federal tax advice contained in this communication is not intended or written to be used, and cannot be used by any taxpayer, for the purposes of I. Avoiding penalties under the Internal Revenue Code, or E. Promoting, marketing or recommending to another party any transaction or matter addressed herein. Any legal advice expressed in this message is being delivered to you solely for your use in connection with the matters addressed herein and may not be relied upon by any other person or entity or used for any other purpose without our prior written consent. This information is for general non-exhaustive educational purposes only. May be deemed an advertisement by State Bar. All rights reserved in trademark and copyright. Copyright 2022 Rich Rydstrom by Rich Rydstrom, Esq. California Attorney, 1-877 Win4U. Trademark, info@Wealth.Attorney. Trademark.